Welcome to this webcast where I will provide you with an update in respect of our OPES product, given its 14 years of success as a market-leading international retirement plan. I'm not going to consider all the aspects of the product. However, I am going to focus on some of the main features and benefits that OPES has provided to clients over the years and help to differentiate our product from many of the alternatives you'll find in the market. Firstly, I'm going to consider matters of succession and probate, and I can confirm that the options with respect to succession remain unchanged and continue to operate as they always have. This provides members with significant flexibility in how they wish the death benefit to be dealt with and how and to whom benefits flow from the fund on the member's passing. So an ideal structure for planning for the succession of wealth. Obviously, hand in hand with succession is all matters of probate. And as with the point on succession, the benefits of probate remain unchanged for OPES. Those benefits we have seen typically include things such as the mitigation of all foreign situs issues, the mitigation of need for foreign will and foreign death duties that may arise if the individual held those assets in their own name at the time of passing. In addition, it mitigates programmed or forced heirship rules where an individual should die without a will covering foreign assets. From a South African perspective, I can also confirm that the assets held within the OPES are dealt with by the pension trustees on the member's passing, and there's no need for a South African will, nor for the involvement of local executors. The benefit to the clients is a cost-effective and timely wind-up and passing on of wealth in a manner that they wish to the beneficiaries that they wish to have it passed to at what is typically a very difficult time for families, given the passing of a matriarch or patriarch. I also want to consider matters of asset protection. And here I can confirm that the protection, the legal protection that OPES has enjoyed, the robust framework it has provided for clients persists as well. However, we've added 2 additional contractual devices into the OPES product, and the first one is very specific bankruptcy protection. If something happens to a member in OPES and they become bankrupt, their benefits and the interests in the plan have legal protection. Why have we added this? We have a significant number of entrepreneurs and practitioners in very specialist fields that have put assets into OPES. And therefore, the risk of these individuals ending up in some form of litigation is always high, and therefore enhanced protections over and above the regulatory and statutory protections that already exist. So an enhancement to the already very effective protections in respect of one's assets when sitting inside OPES. When considering taxation, OPES remains exempt from tax in Guernsey, which means the member only has to consider the tax position in South Africa. On this point, I can confirm there are no changes with respect to tax in terms of contributions made to the plan, gains and income accruing in the plan, or the taxation of income and gains when distributed as a benefit payment from the plan. However, when considering taxation, one must have regard for future possible changes, and as such, we are adopting a different position with respect to estate duty. Whilst there hasn't been any specific changes to tax law in South Africa, we foresee possible changes which are being driven through social policy, which will focus on the alleviation of poverty through wealth distribution. Given this direction, it is prudent to consider such matters when presenting the product to prospective customers in order to set their expectations should these events unfold as we foresee. In the next slide, I will provide a working example of what I actually mean by this and the implications for clients. This example is based on the most common scenario we see, where an individual has made provision for retirement into OPES, and upon their passing, the death benefit is used to establish an OPES in the name of the remaining spouse, following which the spouse becomes the member. So in our example, Mr. Smith has established an OPES into which he has contributed $100, and at the time of his passing, it has grown in value to $200. Now, what I can confirm here is that on his passing, the assets or the death benefit is used to set up a new OPES for his spouse, and that the assets transfer into the new OPES outside of his estate. And neither do they form part or are they deemed to be part of his estate. So if we look at the practical, physical transfer of those funds, they sit outside of his estate and are dealt with outside of his estate by the pension trustees, specifically to ensure the funding of the new OPES for his spouse. However, we believe it is now prudent to consider the contribution made by Mr. Smith as dutiable in the estate. In other words, it should be considered when calculating estate duty liability. Although, as already mentioned, the assets do not physically flow through the estate or form part of the estate. So if we go back to this example, the contribution now becomes assessable in terms of estate duty in Mr. Smith's estate, which is the $100, the original contribution. In my example, Mr. Smith has never drawn at all, and the contribution remains intact. So as I said, if we go back to the example, the contribution now becomes assessable in terms of estate duty, and as Mrs. Smith is the benefactor, the assessment provides an exemption in respect of the estate duty. The net result is that this process ensures a clear assessment for tax, although current tax laws exempts the portion of the estate left to the spouse, which results in no estate duty. Now, if we consider the benefits for Mrs. Smith, we identify that there's no foreign situs, no will or probate process, either in South Africa or abroad. There are no delays in ensuring that benefit is available to Mrs. Smith, no need for executors or wills, as I've mentioned. The contribution to Mrs. Smith's OPES is rebased at $200 and forms the new capital value. The assets on Mrs. Smith's passing, including the $200 and all gains, sit outside of Mrs. Smith's estate, as she never made the contributions, nor were the assets ever her property or deemed property. Importantly, the contribution of Mr. Smith has already been assessed and found to be exempt from estate duty. Last point to make here is that it's worth noting that not all contributions to OPES would give rise to an estate duty assessment, and this depends on whether the contributions have been made by third parties. So let me give you some examples. An employer contributes to an OPES as a benefit. That would not be dutiable in the estate. The ownership of those assets were the employers and not the members. Benefits received from a trust. A trust might make a distribution to an OPES for a member, and that would then fall outside of the estate. A pension transfer, consolidating another pension into OPES. Again, the contribution is made by a third party, or indeed just another individual gifting assets into OPES would find that those contributions are not assessable for estate duty under current rules or under current laws, as they do not form property of the individual. So in summary, we believe that by having taken all of the matters into account and in particular the direction of policy in South Africa, that consideration with respect to estate duty really is an important point, and that advisors, you should take a considered and mindful approach, which is conservative and forward-looking. We believe that the approach here provides significant and improved certainty on matters of the estate, and importantly, it fits within the current framework with regards to estate duty in South Africa. This is my last slide, and I really just want to return to the reasons as to why do clients in South Africa utilize OPES. These points are all very well known, and it's the uncertainty, it's the risks that come with the political landscape in South Africa, which flows through to currency risk and economic risk, investment risk, together with the risks of ownership of assets and ownership of property, and the implications of taxation that come with those risks. Lots and lots of uncertainty, which obviously, as we've already discussed, open addresses. So OPES provides the certainty where there is uncertainty, but with it come a whole range of additional features apart from just the peace of mind and the protection that it provides. It's the accessibility, the portability, the freedom of investment, the levels of protection, the mitigation of probate, and the simplification of a client's affairs, where often clients will hold assets in multiple structures or in multiple accounts. So, as I said, lots and lots of benefits that have a real implication for clients. OPES addresses all of these matters in a way that no domestic product can, and provides the significant levels of certainty through the mechanism of internationalization of clients' wealth into retirement structures. Lastly, over the last 14 years, we have seen firsthand how advisors have provided significant benefit to their clients and their clients' families through the use of products such as OPES. And the outcomes I can best summarize as providing clients with real peace of mind and certainty in what is a very uncertain world. As always, you can get more information from contacting our business development specialists. You can also contact us directly, but do keep your eyes and ears open, as we will be providing you with updated case studies, sales guides, and key features and benefit documentation over the coming weeks. So yes, as I said, do keep your eyes open for those. Lastly, but by no means least, I'd like to say a very big thank you to all of you advisors that are listening to this, that have supported us and put trust in us as a firm, and your clients' trust in products like OPES. Thank you very much.